ফারজানাস ল স্কুলের পক্ষ থেকে আপনাদেরকে স্বাগতম। আমি আছি আপনার সাথে অ্যাডভোকেট ফারজানা শারমিন। আমি আজ কোড অফ ক্রিমিনাল প্রসিডিওর সম্পর্কে আলোচনা করব, যা আপনাদের ভাইবা এবং এমসিকিউতে কাজে লাগবে বলে আমি মনে করছি। সেকশন 200, এ ম্যাজিস্ট্রেট টেকিং কগনিজেন্স of an offence on complaint shall 7. Once examine upon oath the complainant and such of the witnesses present, if any, as he may consider necessary, and the substance of the examination shall be reduced to writing and shall be signed by the complainant or witness so examined, and also by the magistrate, provided as follows: when the complaint is made in writing, nothing herein contained shall be deemed to require such examination before transferring the case under section 192. A. When the complaint is made in writing, nothing herein contained shall be deemed to require such examination in any case in which the complaint has been made by a court or by a public servant acting or purporting to act in the discharge of his official duties. C. When the case has been transferred under section 192 and the magistrate so transferring it has already examined the complainant and the witness, if any, the magistrate to whom it is so transferred shall not be bound to re-examine them. Section 201. Procedure by magistrate not competent to take cognizance of the case. 1. If the complaint has been made in writing to a magistrate who is not competent to take cognizance of the case, he shall return the complaint for presentation to the proper court with an endorsement to that effect. 2. If the complaint has been made in writing, such magistrate shall direct the complainant to the proper court. 202. 1. Any magistrate or receipt of a complaint of an offence of which he is authorized to take cognizance or which has been transferred to him under section 192 may, if he thinks fit, for reasons to be recorded in writing, postpone the issue of process for compelling the attendance of the person complained against, and either inquire into the case himself, or if he is a magistrate other than a magistrate of the third class, direct and the inquiry or investigation to be made by any magistrate subordinate to him, or by a police officer, or by such other person as he thinks fit for the purpose of ascertaining the truth or falsehood of the complaint, provided that, save where the complaint has been made by a court, no such direction shall be made unless the provision of section 200 have been complied with. Provided further that where it appears to magistrate that the offence complained of is terrible exclusively by a court of session, the magistrate may postpone the issue of process for compelling the attendance of the person complained against, and may make or cause to be made an inquiry or investigation as mentioned in the subsection for the purpose of ascertaining the truth or falsehood of the complaint. If any inquiry or investigation under the section made by person not being a magistrate or a police officer, such person shall exercise all the powers conferred by this code on an officer in charge of police station, except that he shall not have been powered to arrest without warrant. 2a. Any magistrate inquiring into a case under this section may, if he thinks fit, take evidence of witness on oath, provided that if it appears to the magistrate that the offence complained of is triable exclusively by the course of sessions, he shall call upon the complainant to procedure all his witnesses and examine them on oath. To B. Where the police submits the final report, the magistrate shall be competent to accept such report and discharge the accused. (237) Section. If in the case mentioned in the section 236, the accused is charged with one offence, and it appears in evidence that he committed a different offence for which he might have been charged under the provisions of that section, he may be convicted of the offence which he is shown to have committed, although he has not charged with it. Illustration. A is charged with theft. It appears that he committed the offence of criminal breach of trust or that of receiving stolen goods. He may be convicted of criminal breach of trust or of receiving stolen goods, as the case may be, though he was not charged with such offence. Section 243. Conviction on admission of the truth of accusation. If the accused admits that he had committed the offence with which he is charged, his admission shall be recorded as nearly as possible in the words used by him, and if he shows no sufficient cause why he should not be convicted, the magistrate may convict him accordingly. (265)(1). Entering upon defense. 1. Where the accused is not acquitted under section 265A, he shall be called. 265 I. Where the accused is not acquitted under section 265A, he shall be called upon to enter on his defense and adduce any evidence he may have in support thereof. 2. If the accused puts in any written statement, the court shall file it with the record. 3. If the accused applies for the issues of any process for compelling the attendance of any witness or the production of any document or thing, the court shall issue such process unless he considers, for reasons to record it, that such application should be refused on the ground that is made for the purpose of vexation or delay for defeating the ends of the justice. Section 352, courts to be open. The place in which any criminal court is held for the purpose of inquiring into or trying any offence shall be deemed an open court to which the public generally may have accused, so far as the same can conveniently contain them, provided that presiding judge or magistrate may, if he thinks fit, order at any stage of any inquiry into or trial of any particular case that the public generally or any particular person shall not have accused to or be or remain in the room or building used by the court. Section 384, direction of warrant for accusation. Um, 384, direction of warrant for execution. Every warrant for the execution of a sentence of imprisonment shall be directed to the officer in charge of the jail or other place in which the prisoner is or is to be confined. Section 385, warrant with whom to be lodged. When the prisoner is to be confined in a jail, the warrant shall be lodged with the jailor. 386, section, warrant for levy of fine. Whenever an offender has been sentenced to pay a fine, the court passing the sentence may take action for the recovery of the fine in either or both of the following ways. That is to say, it may A. Issue a warrant for the levy of the amount by attachment and sale of any movable property belonging to the offender. B. Issue a warrant to the collector of the district authorizing him to realize the amount by execution according to civil process against the movable or immovable property or both of the defaulter, provided that if the sentence directs that in default of the payment of the fine, the offender shall be imprisoned, and if such offender has undergone the whole of such imprisonment in default, no court shall issue such warrant unless for special reasons to be recorded in written in considers it necessary to do so. 2. The government may make rules regulating the manner in which warrant under subsection 1, clause A, are to be executed, and for the summary determination of any claims made by any person other than the offender in respect of any property attached in execution of such warrant. 3. When the court issue a warrant to the collector under subsection 1, clause B, such warrant shall be deemed to be a decree, and the collector to be decree holder within the meaning of the Code of Civil Procedure 1908. And 1908. And the nearest civil court by the which any decree for a like amount could be executed shall for the purposes of the said court be deemed to be the court who is part the decree, and all the provisions of that court as to execution of decrees shall apply accordingly, provided that no such warrant shall be executed by the arrest or detention in prison of the offender. Section 393. Not to be executed by the installments exemptions. No sentence of whipping shall be executed by installment, and none of the following persons shall be punishable with whipping, namely, a female be male sentenced to death or to transportation or to imprisonment for more than 5 years. C. Males whom the court considers to be more than 45 years of age. 394. The punishment of the whipping shall not be inflicted unless a medical officer, if present, certifies, or if there is not medical officer present, unless it appears to the magistrate or officer present that the offender is in a fit state of the health to undergo such punishment. If during the execution of the sentence of whipping a medical officer certifies, or it appears to magistrate or officer present that the offender is not in a fit state of health to undergo the remainder of sentence, the whipping shall be finally stopped. 2. আজকের মতো এখানে শেষ করছি। আমার চ্যানেলটি ভালো লেগে থাকলে চ্যানেলটি লাইক করুন, শেয়ার করুন, সাবস্ক্রাইব করুন, পাশ থেকে বেল বাটনটি প্রেস করুন। ভিডিওটি শেষ পর্যন্ত দেখার জন্য অসংখ্য ধন্যবাদ।